It's not something that can be easily measured with a blood test or an X-ray or something that you can put before the court to understand. It was settled for $10 million, having sort of helped these women in the last phase of their battle against a system that was really not set up to in any way recognize the harms that they had experienced. I think that they knew in their bones that what had happened to them was wrong, and that if the law didn't yet afford them a remedy, then it was time to create one.
One Great Case, a podcast about law to learn more about people. I'm your host, Areta Lloyd.
We decided to talk about a precedent-setting case today about gender-based violence. It was against the Royal Winnipeg Ballet School and one of its instructors. And when we think about ballet, or at least when I think about ballet, I think about beauty and fairy tales and all things good and wonderful. And ballet as an art form involves the suspension of disbelief and a complete immersion into the art. And what we see is the set and the performance on stage. With that as a start, how would you describe the backstage to the facts that you're going to tell us about?
So I think ballet at its highest level requires extraordinary levels of discipline, extraordinary tolerance for mental and physical discomfort, and extraordinary obedience almost to your instructors or the director of a piece. Dancers, as I understand it, are really taught that their bodies are essentially the medium of this art form and that they are to comply with the direction that's given to those bodies. So that, I think, writ large is the context for this case. The background, in layman's terms, is a bit less esoteric. Essentially, there was a dance teacher named Bruce Monk who taught at the Royal Winnipeg Ballet School in Winnipeg for more than 2 decades. For anybody who's unfamiliar with the Royal Winnipeg Ballet School, it's on par with Canada's National Ballet School in Toronto. It's essentially one of 2 premier dance institutions in the country. And if you aspire to a career as a professional ballerina, it is a key launch pad. And students started attending that school often as young as, I believe, 9 or 10. It's extremely rigorous. It's extremely competitive. And as they progress through their years of study and training, they start to audition for shows and for pieces outside and inside the ballet school. And for that, they need essentially a portfolio, a book of photographs. So I feel like I'm bearing the lead here, but essentially, Monk was well known as the person at the school to go to get your photographs taken. He was a very proficient photographer. He was the school's de facto in-house photographer and was frequently granted access to dancers backstage and behind the scenes in rehearsals, and really documented a lot of the life at the ballet school. So students of the school were very accustomed to seeing Bruce, the camera around his neck, and were accustomed to the fact that the school allowed him to take their photos. In addition to that, they were often encouraged to go see him when they needed portfolio photographs. But in addition to taking photos for their students' portfolios, once Monk had them alone, he had a pattern of encouraging them to essentially remove their clothing and to pose nude for him in photos. Some of the students that we spoke to were as young as 15 or 16 and sort of arguably went up to 18 or 19. But what was common amongst them is that they were students of this school and that they had been photographed by Monk in connection with the school.
with respect to the students and their bodies, they weren't expecting to have nude photos taken, right?
Correct. Yeah. They thought they were going to have professional photos taken to use in their professional portfolios to hand out on auditions. The interesting thing about this case is that in all but one of the cases, there was no physical contact between Monk and the student. And so often what would happen during these photo shoots is that they would escalate to a point where the student was fully nude and posing in quite suggestive or explicit positions. Um, Monk argues that it was for art, for artistic purposes. But if you looked at some of these photos, they didn't feel that artistic. And regardless of what he intended, that's not how they felt to the student. And years later, it was discovered that he was sort of posting and selling at least some of the photographs online through eBay or Etsy or some other sort of photography sites. And so the students learned about this. Meanwhile, what's sort of going along in the background is that the students would have the experience of these photo shoots. They would go away. They would feel deeply ashamed about it. And it would affect them in all sorts of different ways. And some of them over the years reached out to him, sometimes many years later, to say, I've always thought about those photos you took. I'm not comfortable with it. I'd like them back. And sometimes he would return the negatives to them and he would claim that he had destroyed them all, although that later proved to be untrue. So there was this sort of swirl of misconduct around this that these girls, now women, had tried for years and years to try and get someone to take seriously and do something about. They reported what was going on to the police in Winnipeg, and there was a lengthy investigation, but ultimately no charges, in part because of when the definition of child pornography was changed in the criminal code versus when the photographs were taken. Eventually, these dancers went to Maclean's magazine, and there was a big cover story in I believe it was April 2015, called Scandal at the Ballet, that sort of laid out the facts of what had happened in great detail. And you read it and you thought, like, how could this be? And how is it that they have not been able to find any legal pathway to any kind of accountability or compensation? And so that is where I entered the picture. One of the women affected by this, who actually ended up being the representative plaintiff, Sarah Doucette, came into my office with a copy of Maclean's magazine and said, like, can you help me, essentially? So I am not a class actions lawyer by discipline or training, but I do think of class actions as being one of the many tools in my toolkit. And actually, this seemed purpose-built for class actions because each of the claims alone was risky and arguably potentially not worth enough to prosecute on its own. But collectively, there were a lot of common issues. And so we set about trying to launch a claim.
Okay. So tell us a bit about the different players. We have the lead plaintiff, but we have Mr. Monk.
Yeah.
There were other players, and there was some behind the scenes.
There was a tight-knit group of 5 women, some of whom had known each other since their time at the school and some of whom have connected after the fact, but who had sort of been working collectively to try and move this issue forward with the ballet school for years and years. As I said, they had gone to the police in Winnipeg. They had sort of done a lot of their own work, but they were really up against a fairly rigid legal system. So we gathered together this sort of critical mass of a representative plaintiff and also some unofficial representative plaintiffs who played very active roles in moving it forward. They swore affidavits for the certification motion. They were cross-examined. They were really key to the success of the claim. And then, of course, we had the ballet school itself, which was represented by various insurers as things unfolded. So those were the players. That sounds all very straightforward. It was challenging to get this claim launched and to get this claim resolved. And there are lots of reasons for that. If you honestly sort of dial the clock back 9-10 years to when Sarah Doucette first walked into my office, the law then, in terms of its recognition and understanding of the harm that comes from text-facilitated violence, from the non-consensual taking and distribution of photos of your body, was very underdeveloped. And this had been a point of frustration of mine for a long time. It was only in 2015 that Parliament finally amended the criminal code to criminalize the non-consensual distribution of intimate images. So what had sort of been known in the lexicon for a long time as revenge porn.
Tell me a bit about the challenges. I think the limitations was one of the challenges.
So there were a lot of challenges. First, there wasn't a clear, obvious cause of action. And if you look at the certification decision, you'll see that we had a whole bunch in there. The most obvious were sort of negligence. We also pleaded sexual assault, despite the fact that there was no physical contact, because it's actually the tort of battery that is what that responds to when there is physical contact of a sexual nature. The tort of assault is intended to sort of protect you from the psychological damage that comes, in the moments before a physical contact is made. It's supposed to sort of protect your psychological integrity. So we pled assault, breach of fiduciary duty, breach of confidence, intrusion on seclusion, just a whole laundry list of torts, because none of them were the perfect fit.
You're talking about a bunch of torts that weren't even well developed at that point.
Yeah. I mean, certainly the tort of intrusion on seclusion and the 4 privacy torts were extremely underdeveloped. I think Jones and T came out in 2006, but that's really about somebody snooping in somebody else's banking records, right? And so when you think about that we're trying to use law that was sort of designed, to prevent somebody from snooping through your computer, to protect the, physical autonomy of women's bodies, it's a bit of a misfit, but it's all that we had. And so that was challenge number 1. Challenge number 2 is that although limitation periods across the country have been amended to or eliminated for cases of sexual assault, with something like this, it doesn't cleanly fit. And so we were up against limitation periods sort of coast to coast in different provinces. And that was an uphill battle as well. And so we were back sort of fighting about discoverability, and when somebody in the circumstances of these students knew or should have known, not just that they had posed for photos, but also that the posing for photos had caused them harm, and that harm wasn't their fault. There was a Supreme Court test articulated way back in the early aughts about when, a victim of sexual abuse was said to have discovered their case, which was obviously much more complex than just knowing that someone had touched them wrongly. I would say that the more pragmatic challenges were just that the law and many lawyers still do not do an adequate job or any kind of job of understanding the true harm that incurs, particularly to women, from these gendered crimes. The immense psychological damage that can be done from knowing, first, from the betrayal of trust by somebody in a position of power, having gone through the experience of finding yourself naked and being photographed by this person who has tremendous power over you, and the feelings of shame and self-blame that they had to live with, which were intense for some of these students. And then the later finding out that he's been sharing these photos, and whether or not you know for certain that they were photos of you that were shared, just the possibility also causes immense amounts of anxiety and psychological stress. But it's not something that can be easily measured with a blood test or an X-ray or something that you can, put before the court to understand. It's a particular kind of harm that I really think is very gendered in nature. And so, surprise, surprise, the law had not done a good job of recognizing that or affording individuals good tools to deal with it. And so we had that uphill battle as well. We had to convince the defendants, their lawyers, their insurers that this was not a nuisance value claim. So as much as that was a challenge, I also saw it as an incredible opportunity. I think this was an extremely important case in terms of like moving the needle on these types of claims and convincing courts, lawyers, insurers that there is value to these harms because they were certainly experienced as incredibly damaging to my clients. So to jump forward to the end, it was settled for $10 million in late 2021. I think a mere 3 months before we were supposed to go to trial on the common issues. And that was extremely satisfying, having sort of helped these women in the last phase of their battle against a system that was really not set up to in any way recognize the harms that they had experienced.
Talk a little bit about keeping the plaintiffs going throughout this process, because that's that takes some skill and perseverance on your part.
So the plaintiffs kept each other going, first of all. They were a real team, and they were very good at handing off if one of them said, like, I'm out for now. And they were supports to each other. And honestly, in this particular case, they did not need us to push them forward. We had the great privilege of coming in and helping them after they had been battling alone for years and years. So I think that they felt extremely encouraged to finally have lawyers who were prepared to take on their case, which isn't to say that they didn't find it enormously challenging at times, and that they all paid an individual psychological and emotional price for being the ones to push this case forward. But I certainly can't take any of the credit for them stepping forward and having the fortitude to see this through to the end. They were exceptionally determined women, and that is not just some cavalier statement I'm saying, throwing around to say it was a privilege to act for them. It really was a privilege to act for them. So I think that they knew in their bones that what had happened to them was wrong, and that if the law didn't yet afford them a remedy, then it was time to create one.
Okay. And speaking of the remedies and that, tell me a little bit about the occupier's liability.
Okay.
We talked a little bit about that prior to this recording, and it seems so awkward and also, frankly, scary for anybody who might have something occupier's liability.
Well, so some of these photo shoots took place in the Royal Winnipeg Ballet's building. There was a particular studio he liked using. I think it was on the second or third floor because it didn't really have any external windows. And so as the occupier, you have a duty to ensure that students are kept safe. We gathered evidence over the course of the claim, over the course of the litigation, that I think would have demonstrated that the school, outright knew that these photographs were taking place, or at the bare minimum should have known. One of our clients, when she went back to get her photos from Monk many years later, hand wrote essentially some kind of declaration or release that said, you are acknowledging that you've returned all these photos to me and that you've destroyed any other photos and there are no other copies in your possession. It was just something she hand wrote on a piece of foolscap. And it had Monk's signature at the bottom, but it also had the signature of a different dance teacher, somebody she trusted, who she had asked to witness the fact that she was asking for these photos back and he'd given them to her and he was making this declaration. So things like that made us confident that we would prove, probably negligence, but also that as the legal personality responsible for the safety of the people who used that building, this was one of the things that they were obligated to keep them safe against.
And didn't he have an exhibit at some point? I mean, how could one not know?
So he was an art photographer. He actually had photographs that were featured in the Tom Cruise movie Vanilla Sky, if anybody remembers that, way back in the early 90s. And he sometimes had exhibits in Winnipeg. And so there was one time that he was exhibiting photographs that included a nude or semi-nude photograph of a former student who had graduated the year prior. And one of the things that we heard from some of the women who were part of the class is that they recalled going to this art opening while they were still students, and all their teachers were there, and everybody saw this photograph of this very recently former student who had posed, and feeling like, well, they must all know, and this must be okay, right? It was a very confusing thing to see. And then when they later found themselves in these photo shoots, or if they had already been through one, to see that so brazenly up on the wall, they really felt like it was, like that. If the school must know about it and it must be okay. And however I feel about it, this just must be one of the other many times in the dance discipline that I have to sort of push down my feelings of discomfort and give my body over to this supposed art form.
Yeah, it certainly puts them in a powerless position, or at least they feel that way.
Yeah, I mean, you can understand how at 16, 17, you wouldn't know who to go to if it looks like they're all in cahoots. And we had witnesses who would have testified that the director at the time used to call them Bruce's booby photos, and that people sort of joked about them. I mean, there was a lot of evidence that we think would have convinced the court that there was knowledge on the part of the school. So, of course, when we were drafting the claim, we didn't know as much as we came to know over the course of the litigation. And so, believe it or not, breach of the Occupiers Liability Act is something that I often plead because of the fact that these bad actors in positions of power at institutions often use like the physical premises of the institutions and the sort of implicit authority that gives them to abuse the people that they have power over. So I know that one might seem odd, but there was definitely very intentional thought behind it.
So now, today, how would you plead a similar case?
It wouldn't be that much different. I would have greater confidence in my ability to prove damages at the end of the day. But the law as it stands in Ontario hasn't, there haven't been new torts emerge, is maybe a better way to say it. There have been courts that have demonstrated a willingness to use the causes of action that we asserted in this case to respond to claims for voyeurism and claims for the non-consensual dissemination of intimate images. But there isn't like a purpose-built tort for these kinds of things. And so we are using sort of taking the square peg and sort of rounding off the edges and trying to jam it into the hole a little bit to make it work. There are other provinces that have created statutory causes of action to respond to these kinds of harms, wrongs, crimes, whichever language you prefer. BC and Manitoba, for example, both have a statutory cause of action that's sort of connected to this kind of harm that's much more explicitly intended to address this kind of misconduct and to connect people to damages for it. Here in Ontario, we're still sort of MacGyvering things. We're bootstrapping claims onto causes of action that maybe don't cleanly fit, but will work. But when you're determined to make them work.
Wow, that's unbelievable, actually. So we have a fair ways to go.
We, I think, have a ways to go. It's a bit of a mystery passing understanding why the provincial government hasn't acted. 10 years since it became a criminal offense. I think it's close to 20 since the offense of voyeurism was expanded to sort of respond to the new realities of the digital age. I think it's just a lack of prioritizing.
We definitely need crusaders like you and Mar Waddell to be helping these people, because it's not going to be that easy.
It's not easy. It's very satisfying. Looking back on this case, it's been almost 10 years since they first came to me. It is sort of shocking to read the facts again and think that anybody ever thought that this was risky. But it just goes to show that the law is not a static thing. And to repeat one of my favorite lines, it's patriarchal in the sense that it was built by men for men. And it's taken a long time, over many decades and centuries, to evolve to sort of recognize the lived reality of others and to find ways to recognize and compensate harms that aren't always immediately visible. When I look back at some of the early case law for claims for childhood sexual abuse, plaintiffs used to get $20,000, $30,000 total for just horrific abuse. Because I think the judges at the time, who were predominantly men, really saw it as sort of just the discomfort in the moment, that physical discomfort in the moment. And if it didn't leave them with any sort of lasting physical disability, then it was seen as a transient harm. And thank you to all of the lawyers that precede me who did this work and have really worked to move the needle on what these claims are worth and how the courts understand the damage and sort of the lasting impact we understand it has, not just both on individuals, but also society, to move our understanding of that. But that work isn't done. And so finding ways to fold in the new harms that are attendant of this digital age, and cameras everywhere, and now we've got AI and deep fakes and all this other stuff that can be so harmful to the person who's targeted by it. The law needs to be continually pushed to catch up and keep up.
Yeah. Well, we'll be looking for more from you, Jillian, in pushing the common law forward, and hopefully somebody will move the statutory law forward. That would be tremendously helpful.
It would.
Thank you so much for being here. It's a real pleasure to speak with you.
And you. Thanks for having me.